if you don't have a living trust, there is a process that happens at incapacity or death. And it's very important to understand incapacity. It is the probate court in California, and it is the probate court in the vast majority of states throughout the United States. It is a court proceeding that you have to go through if you don't have a plan in place or the plan somehow is defective or out of date. So normal probates are a hassle and very expensive. If you have a will, that is a ticket to probate court. So I'm Jim Cunningham. I'm a partner at Cunningham Legal. I have 30 years experience this year. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust and probate law, securities and insurance licensed, and a pilot. So I have a broad base of knowledge on all things estate planning and how these assets work in the living trust. We have a big group of attorneys here with us now. We are not a big firm. We are what is called a boutique firm. So we're a specialty firm. We essentially handle all things for high net worth individuals, high income individuals, dealing with trusts and trust administration and real estate and business entities. So typically centered around the mass affluent. I'm a lawyer. When I say you, there is no attorney-client relationship. This is not legal advice to you. This is very important to understand. Don't watch this. Go out and do a bunch of stuff just because you saw this on a video. Very, very important. You will want to consult with an attorney. And if you choose to use our firm, great. And if you already have an attorney, that's fine too. But please, this is for information only, maybe a little bit of entertainment. But if you don't have a living trust, there is a process that happens at incapacity or death. And it's very important to understand incapacity. It is the probate court in California, and it is the probate court in the vast majority of states throughout the United States. It is a court proceeding that you have to go through if you don't have a plan in place or the plan somehow is defective or out of date. So normal probates are a hassle and very expensive. If you have a will, that is a ticket to probate court, okay? If you have a will, you're not avoiding probate court. I would say typically, if you have assets currently, as we are doing this webinar in 2024, if your assets are under $185,000 or $184,500, don't know why they didn't round up. If they're under that amount, then it's a different process. It might be a single court hearing. There might be no court hearing. It might be an affidavit procedure, depending on the nature of the assets. And we do cover that in other webinars. There is a bill, AB 2016, that is in the California legislature. It's been sent to the Senate Finance Committee, and it is seeks to raise that limit to $750,000. So that creates a whole other host of issues that I won't get into. If you inherit a condo, you and your jerk brother and your jerk sister, the three of you, and you inherit mom's $600,000 condo, guess what? You still have to sell it. You still have to administer that estate. Now, you may not be in probate, but you're going to have to get along with your two jerk siblings. So probate in California, their lawyers talk about a formal probate. This is not where you put on a tuxedo and tails and spats and a cane and a little top hat. A formal court probate is a very long procedure, and it takes typically 16 to 24 months. The absolute earliest a probate can end is about 9 months. But again, all the stars have to be aligned. The judge has to show up. All the people have to do their job. Everything has to happen on time. And guess what? That doesn't happen, right? Not in the real world. So what we're seeing in the real world is 16 to 24 months. Probate fees are 4 to 8% of the gross value of the estate. So if an estate has no debt, it's going to be 4 to 8% of the assets. But in our example here, Wanda, her probate estate's $1 million, meaning she dies and she owns a house worth $1 million, but there's a $950,000 mortgage. The probate fees are still $50,000. Now that's $25,000 to the lawyer, $25,000 to the executor. So the executor fees are in there. These are not all going to the lawyer. Really, it's slightly less than $25,000, but there are some costs in there, filing fees and appraisals and things like that are court mandated. And, so if people inherit Wanda's assets and it's $1 million estate with a $950,000 mortgage, it's basically 100% probate fee. So you can kind of think of it as a bit of a tax. So, and we have a probate fee calculator on our website. I'd encourage you to check that out. There'll be a link in the notes. And you can put in, if you put in your assets, it'll calculate what the probate fees are in your estate. So the gross value of all your real estate, gross value of your bank accounts. There's some things that aren't included, which we'll cover a little bit later. So, probate, again, it depends on the value of an estate. And these are some snippets from our probate calculator from our website. $1 million estate pays $46,000 in attorney's fees and executor fees. Now, this is excluding costs. So that $50,000 figure I gave includes those costs. Our probate calculator is only calculating the executor and attorney fees. They're not calculating the costs that go with that. A $3 million estate is $86,000, and a $10 million estate is $226,000. I will tell you that when you compare that to the estate planning fees, they're orders of magnitude smaller. It is pennies on the dollar. And you'll see, certainly if you have a larger estate, you absolutely want to stay out of probate court. Another thing, a bad thing about probate is it's all public. So the minute your loved ones inherit from you, that is public knowledge. The amount of their inheritance is public knowledge. So a lot of people don't like that idea. It's a fact, and there's really not a whole lot you can do about it. When is probate necessary? So if you're looking at this and you're thinking, well, I'm mom and dad passed away and I don't know if I need to go to probate, and you're just kind of starting out, or maybe you're in the middle of it and you're like, wow, man, this seems like a waste. When there is no fully funded living trust. Now, what do I mean by fully funded? You can think of a living trust as a bucket, right? It's a bucket with a handle. And when you set up your own living trust, you create this bucket, which is a document, but figuratively a bucket that has a handle. You're the trustee of your living trust typically, and you take your house and you put that into your trust bucket. If you do not put that house into the trust bucket, it is not in the trust. It is not, the trustee has no authority over that property. That is done by deed while you're alive. So most of our clients, when they set up an estate plan, they set up this living trust, and we prepare a deed that the client signs that transfers the property. If I do a trust, it transfers it from me to my living trust, my bucket with my name on it. So it's still mine, okay? You're not losing any control. It's still 100% under your control. That is one method to avoid probate, is a living trust. Well, what if you don't have a living trust and you only have a will, or you don't have a will? If you have a will does not get you out of probate court. It just doesn't. A will is a list of instructions and wishes, frankly, to a probate judge that a probate judge can choose to say yes or no to. So it is not a definitive document that the trustee, in the example of a living trust, must follow. A will is really an ask to the courts. The reality is most wills, once are admitted to probate, there's not a problem, but still you have to go through that process. And in California, when assets are under $184,500, this is not real property, you do not have to go to court. So if you only had a bank account with $100,000, you have to wait 40 days. And then you can, the ark was with Noah was out for 40 days and 40 nights. Jesus was in the wilderness for 40 days and 40 nights. And for some strange reason, the time limit is 40 days. So you have to wait 40 days in order to do something. If it's real property, there is an alternative to the full-blown, as we call the full-blown probate procedure, but you still have to go through a court process if you have a $150,000 parcel of property. Probate is the only way to sell, dispose of, or otherwise transfer your decedent's property. So if mom's passed away and the kids want to sell mom's house, mom's not there to sign the deed, right? The court appoints somebody to sign the deed. And we're going to talk about that court process of appointing somebody. There are, however, 10 exceptions to probate, and we'll go through these quickly. We already mentioned the living trust. Joint tenancy, very dangerous tool, quite frankly. It's kind of like running with scissors. Joint tenancy can have a lot of unanticipated consequences, but for the purposes here, if there are two people on title and one dies, last man or last woman standing gets the property. If both joint tenants die, and there are two joint tenants, it's going to be the survivor's estate. So you still might be stuck with probate. It's more of a delay tactic. Community property, and I'll put an asterisk there. Community property with the right of survivorship is a way to take title to a deed. And what we're talking about here is some of these are different ways to take title. So when you go to buy a piece of property in California, you typically go through an escrow. The escrow will ask you, how do you want to hold title? They give you 9 options. And even as a lawyer, when I buy a piece of property, I'm like, oh, wow, there's a lot of options. Community property requires typically a single court hearing, not a full-blown probate process, the 16 to 24-month process. Community property with right of survivorship avoids probate if one spouse dies. Again, if both spouses are deceased, you have a probate. There's a revocable transfer on death deed. Again, it's kind of like joint tenancy, running with scissors, not really a good idea. It mandatory Medi-Cal reimbursement. There's a lot of bad stuff that comes with it. It's also a public document. So yes, it avoids probate. It's a public document. I believe there's one case out there where the child who was supposed to receive the property declared bankruptcy,
and the court, the federal court, which is the bankruptcy court, ordered mom not to change the deed so that when the mom died, that property goes to the kids' creditors. So I believe there's one case out there. So kind of scary. Spousal property petition is typically with community property. That is the abbreviated, that is the process that you probate community property. So this is between spouses. There's a Hegstead petition and an Uxted petition. These are not made up names. These are real names. And the Hegstead petition stands for the proposition that the property was in the trust and now it's out. It was in the trust, but then like it got refinanced and taken out. There's typically a single court hearing you can go to put it back in. Uxted says that the property was never in the trust, but there was some type of memorandum or writing or some other evidence to show that the person who created the trust intended for this property to be in the trust, okay? And again, that's going to be typically a single court hearing in a probate court, not the full-blown 16 to 24-month process. In probate, there's an affidavit of real property of small value. We don't see this a lot in California. If it's under $61,500, it's a different process. It's an affidavit proceeding. If it's between $61,500 and $184,500, it's typically a single court hearing. And that would be your petition to determine succession to real property. So those are the 10 ways to avoid probate or to not have to go through the probate process as well. I would say those are not great planning strategies. Okay, so don't rely on that as a planning strategy.
How to best prepare before the meeting with the lawyer. Educate yourself. If you go to our YouTube, you might be watching this on YouTube, but we're doing this live. We have over 200 videos in this format of education, right? It's free. This is just out there for the world. Subscribe to our YouTube channel and you click the bell, you'll get alerted by Savvy Estate Planning, what you need to know before you hire a right lawyer, right? That's a really good way because we cover a lot of concepts. We cover a lot of just things that are good to know before you go to the lawyer. This is very important before you go to the lawyer, and be prepared to discuss key decisions. Who will oversee you, right? If you become incapacitated, who's going to take care of you? Who's going to take care of your stuff? Who gets it, right? Think about this before you go to the lawyer, right? Because the lawyer's going to ask you. I don't care what lawyer you go to do estate planning. They're going to ask the same question. They're going to ask these questions, right? And please give information when asked. The information provided to a lawyer is maintained in confidence. Very important to understand. If you use a non-lawyer, that is not privilege. So communications with a lawyer are protected by attorney-client privilege. If you do not use a lawyer, you are not protected by attorney-client privilege. And on that happy note, so why do people use living trusts? You might hear a lot about a living trust. What's going on here? Why do people use a living trust? Well, they use it for a variety of reasons. Estate planning, peace of mind. All my affairs are set up, are in order. Death tax planning, a living trust can, in some instances, reduce death taxes on the death of a surviving spouse. Inheritance protection, I think, is really a big, it's really popular with our clients because they say, look, I don't want a future ex-son-in-law or future ex-daughter-in-law ending up with what I spent a lifetime accumulating. I want that going to my kids, okay? A living trust can avoid probate and protect your legacy and as we're talking about this sort of inheritance protection, this asset protection for inheritances when it goes to your loved ones, minimize federal and state death taxes. Some states have death taxes, and so it's very important to pay attention to that. We change the architecture for living trust depending on if there's a state tax involved. Really, a living trust, you can think about it as a bucket with a handle. The trustee is holding onto the handle. The bucket is the living trust, and you put your house, your stocks, your bonds, your mutual funds inside of that bucket. And then as trustee, you hold on to that bucket. So when you die as trustee, that bucket passes to the successor trustee who's named in the trust and then who holds the handle and distributes those assets as directed under the terms of the trust. So living trusts are the core of many plans. And fundamentally, the reason people do them is they provide peace of mind that that when you're done with this process with the lawyer of creating and funding the trust, that now that if something happens to you, what you have spent a lifetime. And if you think about this, we spend a lot of our time accumulating wealth and taking care of it so that we can retire one day, right? Or not have to work. And when we leave this earth, all of that's left behind. You don't take it with you. That goes to the next generation or goes to your loved ones. And why not protect it? It makes sense to protect it because too often these inheritances, they're either squandered or they're lost in divorce or they go to taxes, and really nobody wants that. If you only do a will or a living trust, again, these are some other documents. So we've seen before that, the HIPAA authorization and advanced healthcare directive deal with your healthcare decision making and who has access to your healthcare. A durable power of attorney for property is still needed if you have a living trust, because you might have an IRA, a 401k, a 403b, a TSA, life insurance, or annuities outside of the trust. And those assets still need to be managed while you're alive. And that's when the durable power of attorney comes in. And that's the agent, also known as attorney in fact. In our firm, we use the term agent because attorney in fact is confusing. People think it's us, and it's not. It's that person that you name to act on your behalf. And then you have to be mindful of your beneficiary designations, your life insurance, annuities, IRAs, 401ks, because neither your will nor your trust direct who gets those assets. That happens at the institutional level. So where you have your life insurance, it's the life insurance company has a beneficiary designation, right? When you die, somebody shows up with a death certificate, that person's going to get the money. Doesn't matter what your living trust says. The life insurance company is not asking for the living trust, unless, of course, you leave your life insurance to your living trust. And sometimes that makes sense, and sometimes it doesn't. Guardian nominations for minor children are often found in the will. There is also a standalone guardianship designation. So if you're concerned you may have a period of incapacity but not be dead, there is a standalone form that you can use that, for in some instances, we use with our clients to designate if you're going to be sick or something, or some people become incarcerated and they can't be, can't decide for their children, then you would want to name a guardian. And then funding your living trust, that's getting your assets. You've got your bucket and your handle. It's getting assets in your living trust and making sure that that's appropriately funded. I would say this is an ongoing function. And what we see is leakage, if you will. Like sometimes the properties leak out of the trust because you refinance your property. We saw a lot of refinance activity, not so much now because interest rates are up, but people would refinance their property and the mortgage company would say, we don't want to deal with your living trust. Just take it out of your trust and make sure to put it back in after you get your loan. Well, a lot of people don't put that back in after they get their loan. And then that's not in your trust. And then if you pass away or become incapacitated, there's some extra work that has to happen. You may in fact end up in probate court. And that's really why you're trying to avoid probate court when you set up a living trust. So again, a trust is like a bucket. It's got a handle. You put your house, investment property, stocks, bonds, mutual funds, investments, go into living trusts, go into the living trust. Things that pass by beneficiary designation, life insurance, IRAs, 401ks, annuities, stay out of the trust. All trusts must have a trustee. Let me say that again. All trusts must have a trustee. They must have a beneficiary, somebody who gets it, and they must have a trust corpus, which is stuff. If one of those is missing, you don't have a trust. Okay. Now, that's why it's important if you don't do the DIY trust. It's a bad idea because there's a lot of stuff in there. There are terms that need to be in there that if they aren't in there, that trust may just end. And that's a real problem. So very important to understand three things: trustee, beneficiary, and corpus. Trusts take care of your assets while you're alive, and you're the one holding on to the handle on the bucket. Well, if you become incapacitated, and typically mentally incapacitated, stroke, dementia, Parkinson's, Alzheimer's, something like that, old age, infirmity, that bucket passes to a successor trustee. Now, if you're still alive, you're still the beneficiary. So that person uses those assets for your benefit. Choose well, my friend, because a living trust does not have any court supervision. Living trust, zero court supervision. That trustee could run away with all your assets. So it doesn't happen a lot. It happens, doesn't happen a lot, but pick somebody who is responsible and knows what they're doing. So we learned this in law school. Do not pick somebody who is empty of head and white of heart. A really good person, but has no idea how to be a trustee. You probably want to move on to the next option on that one. So a living trust is designed to protect your financial legacy from your heirs, divorce, taxes, and creditors. And also, to a certain extent, potentially your probate creditors. So many times when a probate action is opened, and a living trust is designed to avoid this, but when a probate action is opened, many people show up and say, hey, I was owed money, and then you have to pay them, right? You don't have an option. With a living trust, you don't have that process. A living trust typically becomes irrevocable at death and is revocable and amendable during life. So you create the trust, and if you change your mind, you can change the terms of the trust, so it's not carved in stone. A funded living trust makes everyone's life easier. We talk about this a lot in my book, Savvy Estate Planning, What You Need to Know Before You Hire the Right Lawyer. That's available on Amazon and on our website. I really encourage you to take a look at that. I met with a client this week who said, I reread your book. So there's a lot in there about concepts, and we tell a lot of stories. It's not black letter law, so it's kind of in the spirit of the webinars that we're doing here. So something that's available on our website as well as Amazon. We will end with our office locations in Northern and Southern California, the Golden Gate Bridge and palm trees. Subscribe to our YouTube page. If you love our webinars, please go to Google and give us a favorable review. We love favorable reviews. I will be on a hiatus for 3 weeks, and Tasha is going to do my law partner, Tasha, is going to do second marriages and living trust, blended families and their unique challenges. So this is a good one. So think of Brady Bunch. That's what Tasha's going to be talking about. So we'll open it up for questions. If you're watching this on YouTube, please continue watching, because magically another video, if you've made it this far, another video will roll up right after this one. Thanks for watching.